original jurisdiction under all treaties. You got to really understand why the Moors were subjugated around the world, because we were holding a woman high. Okay, we were on number 1. Can you read again, good brother?
Yeah.
Okay, what are we talking about? Article 60, what's the title?
Termination or suspension of the operation of a treaty as a consequence of its breach. Number 1, a material breach of a bilateral treaty by one of the parties entitles the other to invoke the breach as a ground for terminating the treaty or suspending its operation in whole or in part.
Continue.
Number 2, a material breach of a multilateral treaty by one of the parties entitles A, the other parties by unanimous agreement to suspend the operation of the treaty in whole or in part, or to terminate it either in the relations between themselves in the defaulting state, or as between all the parties. B, a party specifically affected by the breach to invoke it as a ground for suspending the operation of the treaty in whole or in part in the relations between itself and the defaulting state. C, any party other than the defaulting state to invoke the breach as a ground for suspending the operation of the treaty in whole or in part with respect to itself, if the treaty is of such a character that a material breach of its provisions by one party radically changes the position of every party with respect to the further performance of its obligations under the treaty.
Okay, let's stop right there.
Yep.
Let's go back to the beginning, then we can get back to C, because they're telling you a lot. You need to comprehend really what they're saying. Okay, what are we talking about? Termination or suspension. What does suspension mean?
Putting it on hold
Mhm.
for a certain time frame.
Exactly, right? So terminate is final.
Right.
Suspension is kind of sort of putting it on hold, but it's pending termination, right? Of an operation of a treaty as a consequence of its breach. So as a hajib, as we're reading these documentations, and we're now dealing with, when you're dealing with the pseudo courts, de facto government, we're using diplomatic mediation and arbitration right now to try to discuss a settlement of affairs between two separate nations. However, they don't want to agree to the proper terms and conditions of the treaty. The next step is, now we must now submit it to the ICJ to report a breach. Okay, it says material. You see the word material? A material breach. What does material mean? You must have a material fact. You can't go up there with your abstract where they hurt my feelings. You have to have proof thereof. So therefore, when I went through my evictions, I was looking for material facts to show that they're breaching the treaty. What they're doing to brother I knew right now is a material fact that they're breaching the treaties. These are all what they call, when you're from a plaintiff perspective, inculpatory evidence. Inculpatory evidence.
Exculpatory.
Exculpatory when you're the defendant. You're on the defense side.
Inculpatory.
Inculpatory evidence. And from the defense side, it's exculpatory evidence. So you gotta look those words up, all right? Meaning, inculpatory means the plaintiff, the burden of proof is on the plaintiff. So the plaintiff has to give the defense all of their information based upon whatever exhibits they have that would prove their side of the equation. They have to, by law, give up 100%, not 99, 100% of their evidence. Inculpatory. They have to inject it.
That's the
defense.
That's the
Person's on the offense, plaintiff. They're on the offense.
Okay.
But they have to prove their case beyond a reasonable doubt with all of their exhibits based upon what they call their evidence. Inculpatory. The defense is over here in exculpatory to be able to defend themselves. And meaning to exclude themselves from wherever the plaintiff is presenting. So if we're the plaintiff, we must put on the record no naked allegations. We must prove that there's a breach through material facts, not our abstract thinking. A lot of Moors been making that mistake. Well, we're Moors. Sounds good. Prove it. Where's your material fact? Your ID isn't valid. When we get all mad in our abstract thinking. What are they telling us? What is the pseudo de facto United States, not to be confused, the United States of America, telling us when they say your ID is invalid? They're telling you, without telling you, prove that it's valid. Where's your material fact that came from your government that issued it to you? Did you put together your politics to issue an ID from your validated government and constitution, etc.? They've been giving us the answers to this test the whole time, but we haven't been able to read and comprehend what's happening. We keep giving the United States corporation an opportunity to get out because the glove don't fit. Because our presentment is wrong. Not AMPAC's, because AMPAC now is in an inculpatory position where we're presenting material facts, but the first thing we had to do is be the people first, politics second, i.e. government, constitution, consular court. We're poised now to go and make our claim. So what are we saying here? Let's take a look, get back to point. A material breach, not your abstract, of a bilateral treaty. What's the bilateral treaty? Morocco, United States of America. By one of the parties, so when you use the word party, the parties must be known in any contract. Well, who are the parties to the Treaty of Peace and Friendship? Anybody, can you tell me?
Morocco and the United States Republic.
Negative.
No, democracy.
No.
Next, anybody else?
Morocco and the United States of America.
That's correct. Must be specific. The parties must be known. Any deviation from that, you're working outside of the contract. All right, let's continue. Good brother, if you can go back to, let's really understand this now. Article 60, they're talking bilateral, we're talking multilateral, bilateral. That what's the parable? Treaty of Peace and Friendship, 1786-87, and the 1836, we're talking bilateral treaty of breaches, because they have breached effectively since 1871, but more specifically 1861. But on their record, 1871 would expose the fraud through their Congress and created what's called a bill of attainder ex post facto. What does ex post facto mean? After the fact. After what fact? After the contract was wrote, and they turned around and wrote something else that had nothing to do with the original contract. That makes them an outlaw because they're working outside of the law of the contract. They did something over here without consent. That's called the Act of Congress 1871, as well as the Naturalization Act of 1870, as well as the 1968 Article 14.
1868.
1868, thank you, Haji. All those are bills of attainder ex post facto. They created bills after the fact and signed them into law. It's all fraud, hypothecation, and it's cheap through usurpation, use of force. Let's continue. Good brother Dre, you were reading.
I was on.
Let's get back to C.
You want to go back to C?
Yep.
Okay. Any party other than the defaulting state to invoke the breach as a ground for suspending the operation of the treaty in whole or in part with respect to itself, if the treaty is of such a character that a material breach of its provisions by one party radically changes the position of every party with respect to the further performance of its obligations under the treaty.
What radically changed? Naturalization Act. What radically changed? Act of Congress, 1871. Radically changed even before those two. 1868 14th Amendment person, which created a domino effect for all your secret societies to now sprout up from everywhere because they were imposters taking the place of the Moors. Call themselves basically Allodium, but they come up with semantic words through what's called connotative linguistics. Now all of a sudden they're citizens, they are what you call white people. They have all these different names now that way they can try to claim themselves as being the sovereign. Instead of it being a Allodium title, now they got mortgages and deeds. Instead of being common law, now it's common law with a hyphen, making it a compound adjective. Instead of you being naturally born, 2 words, now under their legality, they put both words together with a hyphen in the middle. Natural born, hyphen, compound adjective. What does that mean? You're an alien, because a compound adjective is not a noun. All this is radical changes. So therefore, when you read the 1514 Declaration of 1960, its first article says what? The people have been turned into what? Aliens. That's radical. That's a breach. We've been turned into black people. In their own definition of black person in the Black's Law Dictionary, 4th edition, it says generic. What does that mean? If you're the generic drug, then what is the original? They say you're the knockoff. Then what's the original? More is the original. So there's a breach. Breach of what? Performance of obligations. Obligations. Okay, number 3, good brother.
Number 3, a material breach of a treaty for the purposes of this article consists in A.
Speak up.
Hold on, let me try that. A repudiation of the treaty not sanctioned by the present convention, or B, the violation of a provision essential to the accomplishment of the object or purpose of the treaty. Number 4.
So let's stop right there.
Okay.
Number 3, a material breach of treaty. Material breach of treaty. Material breach of treaty. For the purposes of this article consists in a repudiation of the treaty not sanctioned by the present convention. What does that mean? Repudiation of the treaty not sanctioned by the present convention.
Well, what does
Meaning if the UN, etc., are not going to recognize some little secret Treaty of Verona, it has no judicial standing in law. There cannot be any doctrines of discovery. Can't be any unum sanctum policies. Because treaty means how you treat one another. It can't be sanctioned, which means it has no judicial standing in law. Your e pluribus unum that the United States refers to in many one, but what many are they talking about? Ain't got nothing to do with Moors. So it can't stand up as having any judicial standing in law. Okay? That's what repudiation of the treaty not sanctioned by the present convention. What they want to say is doctrines. That's why the rights of indigenous people, right in the preamble that they call the annex, it says that the rights of the indigenous people are equal rights. And anything that discriminates them is legally invalid, scientifically false, socially, I think, condemnable and morally unjust, something like that. Because it's a repudiation of those doctrines. And that's another word that's in there, doctrines. Let's talk about it.
Say that one more time.
So superiority over people are doctrines that is a repudiation of doctrines not sanctioned by the present convention. Because those are treaties amongst a small group, secret societies. That's their treaty. It's outlawed. Anything that puts a person in a superior position based upon something negative is outlawed if it goes against the mother. Let's continue. Number B, the violation of a provision essential to the accomplishment of the object or purpose of the treaty. The Treaty of Peace and Friendship was between Moors and citizens of the United States. They still call themselves citizens of the United States of America, I should say, but now citizens of the United States, and when all of a sudden we became black. So therefore, under B, the violation of a provision essential to the accomplishment of the object or purpose of the treaty. What was the treaty purpose? Treaty of peace and friendship in order to establish commerce. But they eradicated peace and friendship and eradicated amity, because amity means friendship, tranquility. They just write into commerce. So what does violation mean? Violent. Violent. Violent against who? Nation. Violent. Violation. Violation. Violent against nation. Violating nations. Violations. Compound word. Violating what? Human rights under common law, violating the mothers. Let's continue. Number 4, the foregoing paragraphs are without prejudice to any provision in the treaty applicable in the event of a breach. So did we read 4? I don't think we read 4.
No.
Okay, that's
It's time. It's too
time.
Yes.
Okay,
it's
let's
time.
stop right there. Based upon the breach of a bilateral treaty of the Vienna Convention.